What if everything you spent the last 30 years building, your pension, your retirement savings, the state you carefully chose to retire in, every financial decision you made based on laws that existed at the time, could be quietly taken away from you by a state legislature trying to close a budget gap? What if the rules you planned your entire life around could simply be rewritten after you had already lived by them for decades? That question just received the most powerful answer possible from the highest court in the United States, and the answer, delivered unanimously by every single justice with zero dissent, was absolutely not. But here is the part that matters most to you personally. This ruling did not just protect some abstract legal principle. It created a brand new constitutional shield around your retirement money. And right now, the overwhelming majority of Americans who benefit from this protection have no idea it exists. I'm Zayne, and welcome to Senior Security Updates, where we make sure you know about every development that directly affects your financial future, in language that is clear, honest, and immediately useful. Today, we are breaking this Supreme Court decision down completely: what it means, who it protects, why it changes the power dynamic between you and your state government, and the specific three-step action plan you can begin using today to make this ruling work for you. Stay with me through every section of this video, because the most actionable part comes near the end, and it could save you thousands of dollars over the course of your retirement. A 9-0 decision that changes everything. Let's start with what makes this ruling genuinely historic, because the nature of this decision makes it far more powerful than a typical Supreme Court ruling. This was not a narrow, contentious 5-4 split that could be reversed by the next administration or the next court. This was 9-0. Every single justice, appointed by presidents from completely different political parties, representing the full ideological spectrum of the court, arrived at exactly the same conclusion. In the legal world, that kind of unanimity carries extraordinary weight. It signals that the principle behind this decision is not a political position. It is a foundational standard of fairness that the entire court considers settled law, and when the Supreme Court speaks with that unified a voice, it creates precedent that shapes policy for decades. But here is what makes this story even more remarkable. This ruling, one that will affect millions of Americans, did not begin with a powerful corporation, a well-funded lobbying group, or a team of high-priced attorneys. It began with one person, a single retiree who received a letter about a new state law, read it carefully, and said, "This is not right. You cannot do this." That one person's refusal to accept an unfair outcome made its way all the way to the Supreme Court. And because of it, every one of us now has a new constitutional right that did not clearly exist before. The power shift, before and after this ruling. To truly appreciate what changed, you need to understand what the landscape looked like before this decision, and how completely it has been reversed. Before this ruling, if a state government decided to change retirement tax laws, modify pension formulas, or alter the financial rules you had been planning around for years, the burden was entirely on you to prove the government acted wrongly. That meant hiring attorneys, navigating a complex legal system, and fighting an expensive uphill battle against a government with virtually unlimited legal resources. For most people, that fight was not realistic. In practice, once the state changed the rules, there was very little individuals could do about it. After this ruling, the dynamic has been completely inverted. The presumption now starts in your favor. When a state wants to change retirement laws in ways that affect people who planned their financial future around those rules, the burden falls on the state to justify the change under a strict constitutional standard. The government must now prove its case, not the other way around. That is a historic rebalancing of power from the institution to the individual. The core concept: your Reliance interest shield. The court built this entire decision around a concept called Reliance interests, and once you understand it, you will immediately see why it is so powerful. Here is what it means in plain language. When you make major long-term decisions, how much to save, when to retire, where to live, which career to pursue, you base those decisions on laws and rules that currently exist. The pension formula your employer offered. The tax treatment your state applies to retirement income. The contribution rules for your 401k. These are not abstractions. They are the foundation of decisions that shape your entire life. When you make those decisions in reliance on existing laws, you create what the court calls a reliance interest. And what the Supreme Court has now said unanimously is that governments carry a constitutional obligation to respect those reliance interests. They cannot simply rewrite the rules after you have already spent decades living by them. Think of it as a two-way contract. You held up your end, saving consistently, planning carefully, contributing to a pension system, making irreversible decisions based on the rules in place. This ruling says the state must honor its end of that agreement as well. And the court did not just announce this principle and leave it vague. They created a specific legal test, called the Reliance Impact Analysis, that every state must now pass before changing retirement laws in ways that harm people who relied on them. The three-part test states must now pass. This is the legal mechanism that gives this ruling genuine teeth. For any state that wants to change retirement laws in a way that affects people who planned their financial lives around them, 3 questions must now be answered, and the bar for each one is extraordinarily high. First, the state must demonstrate that people did not actually rely on the existing law when making long-term decisions. For retirement planning, where people spend decades making decisions based on tax rules, pension formulas, and investment structures, this is nearly impossible to establish. Of course, you relied on the existing rules. That is what planning means. Second, the state must show that the change will not cause material financial harm to the people who relied on the previous rules. If the change costs you money, reduces your pension, increases your taxes on retirement income, or diminishes the benefits you were counting on, that is material harm. This bar is similarly difficult to clear. Third, even if the state somehow passes the first 2 tests, it must then demonstrate a compelling reason so powerful that it justifies the harm caused to individuals who planned in good faith. A budget shortfall is unlikely to qualify. A desire to increase revenue generally will not be sufficient. Before this ruling, you had to prove all of this yourself to challenge a state change. Now the state has to prove it to make the change stick. That is the most significant legal reversal this ruling produces. Who benefits most? 4 groups with new protection. While this ruling applies across the entire country, its impact will be felt most powerfully by 4 specific groups. Here at Senior Security Updates, we want to be specific about who gains the most meaningful protection. Public employees, teachers, firefighters, police officers, government workers. For decades, states facing budget pressure treated pension obligations as an available target. They reduced cost of living adjustments, modified benefit formulas, and raised retirement ages, often for workers already deep into their careers, who had made irreversible decisions based on the original terms. This ruling signals that those workers, having contributed to a system under specific promised terms, now have constitutional grounds to challenge changes that reduce what they were promised. Retirees who relocated based on state tax policies. Every year, significant numbers of Americans make one of the biggest decisions of their lives, selling their homes and moving to a different state specifically because of favorable retirement tax treatment. Imagine spending 40 years in a high-tax state, then carefully researching your options, selling your home, and relocating to a state that does not tax retirement income. Years later, that state introduces a new tax on pension income. Before this ruling, your options were limited. Now, that relocation, that major irreversible life decision made in direct reliance on existing tax law, is a textbook example of a constitutionally protected reliance interest. The court's framework gives you a powerful legal foundation to challenge that change. Workers currently building savings through 401k and similar accounts. Millions of Americans have been contributing to these accounts under a specific set of state and federal tax rules. If a state were to dramatically alter how that retirement income is treated after decades of contributions under the previous framework, the Reliance interest doctrine becomes directly relevant. Social Security recipients in states that tax those benefits. Only a handful of states currently apply taxes to Social Security income, but for retirees in those states, policy changes can significantly affect monthly budgets. The reasoning in this ruling provides a meaningful new framework for challenging changes that materially harm people who structured their finances around earlier rules. Your 3-step action plan. Starting today. Understanding this ruling matters, but here at Senior Security Updates, Zayne and the team always want to give you something you can do right now, not just information to file away. Think of these 3 steps as building a personal fortress around the retirement you have worked decades to secure. Step 1. Document. This is the most critical step, and it costs you nothing but a few minutes of time. Go to your state's Department of Revenue website right now and find the page that explains how retirement income, pensions, and Social Security benefits are taxed in your state. Print it out. Save it as a PDF. Take a screenshot with a timestamp. That document becomes your evidence, proof of what the law said when you were making your financial decisions. Do the same with your pension enrollment materials, your 401k plan summaries, your periodic account statements, and any official correspondence from pension administrators. Every one of these documents helps establish the specific rules you relied upon. If your state ever tries to change those rules in a way that harms you, these records are the foundation of your constitutional argument. If you relocated to a different state because of its retirement tax policies, keep records of that decision as well. Real estate transactions, financial planning notes, any documentation showing that specific tax advantages influenced your choice. Reliance is much easier to demonstrate when it is documented. Step 2. Consult. Share this development with your financial advisor, or if your situation has any complexity, with a qualified tax or legal professional. This ruling changes the strategic landscape of retirement planning in ways that deserve a professional conversation. A qualified advisor can help you identify which parts of your retirement plan depend most heavily on current state policies and what records are most valuable to preserve. This is general educational information. Please consult a qualified financial or legal professional for guidance specific to your personal situation. Step 3. Review. Set a calendar reminder, once a year, to check what your state legislature is currently debating regarding retirement taxes, pension obligations, and related financial policies. A single legislative proposal that seems like a minor technical adjustment could influence your retirement income for years. Staying informed positions you to respond early before changes take effect rather than after. Document, consult, review. 3 steps. That is your personal defense plan under this new legal framework. What states will try next, and how to recognize it? This ruling does not end the conversation. In many respects, it begins a more active phase. State governments that have relied on their ability to modify retirement policies are already working with their legal teams to understand what they can and cannot do going forward. Several strategies are already being discussed in policy circles, and knowing their playbook is your best defense. Grandfather clauses are one common approach. Under this model, existing workers and retirees continue under the original rules while employees hired after a specific date fall under a revised system. This attempts to change future obligations without directly disrupting the reliance interests of people already in the system. Gradual phase-in strategies represent another approach. Rather than implementing a sudden change, a state introduces adjustments slowly over many years, hoping that a longer timeline reduces demonstrable financial harm and improves the policy's legal prospects. And perhaps most importantly, some states will simply pass aggressive reforms and wait to be challenged. They are betting that most people will be too intimidated, too uninformed, or too financially stretched to actually fight back. Knowing this tactic in advance is the first step to countering it. In the wake of this ruling, knowledge is not a vague form of empowerment. It is literally money, your money. Understanding what your state legislature is currently debating knowing which proposals are moving through committee, and recognizing when a proposed change could affect the promises your retirement plan depends on. These are now meaningful components of your financial security strategy. The bigger picture: retirement as a two-way promise. As we bring this together, I want to leave you with the idea at the heart of what the Supreme Court actually decided. For your entire working life, you treated your retirement plan as a promise, a commitment you made to yourself and your family, paid for with decades of disciplined saving, careful planning, and deferred gratification. What the Supreme Court has now said, unanimously, is that your state must treat it as a promise too. The laws they put in place, the pension formulas they offered, the tax treatments they advertised, those are not casual suggestions the government can walk away from whenever the budget gets tight. For the people who organized their entire financial lives around those rules, those laws represent a constitutional commitment. The government cannot simply walk away from it after you have spent decades holding up your end. A court ruling, even a historic one, does not protect you automatically. It is a tool, a shield that has been built and handed to you by the highest court in the land. But a shield sitting unused on the ground protects no one. The only question is whether you are going to pick it up. Document the promises being made to you right now. Stay informed about what your state legislature is considering. And understand that the financial future you worked decades to build now has constitutional protection it did not clearly have before. Here at Senior Security Updates, Zayne and the team will continue tracking how states respond to this ruling and what new developments emerge as this legal landscape evolves. Make sure you are subscribed so you do not miss those updates. Share this video with someone in your life who is approaching retirement or already living on a fixed income, because this information could make a real and lasting difference in how they protect what they have built. And drop a comment below telling the Senior Security Updates team what aspect of your retirement planning this ruling matters most for. Those comments shape what Zayne and the team cover next. This video is intended for general informational and educational purposes only. It does not constitute financial, legal, or tax advice. Please consult a qualified professional for guidance specific to your personal situation and always verify information through official sources. Thanks for watching. Stay informed, stay protected, and we will see you in the next one, right here on Senior Security Updates.